Thank you, and thank you all for staying for the final presentation today. I'm really delighted to be part of the conference to look in detail on what we can do as a community on a growing problem that we're seeing in housing court. When I first was elected to the bench, I had issues of property maintenance and landlord-tenant water shutoffs. And now I'm facing condemned, abandoned properties, property owners who own properties in the city of Cleveland from all over the world, Cayman Islands, Belize, just about every place in the world that there's property ownership. But in addition to all of those issues that we work with in the housing court, we're seeing the issue increasingly of bed bugs. And we are a court that is a specialized court, a specialized docket, having to do with issues of real estate, tenants, landlords, property owners, health department, health codes, fire codes. But the issue increasingly that we see on a weekly basis involves problems as relate to properties, and increasingly we're seeing them with bed bugs. Now, from a national perspective, in 2010, the United States Centers for Disease Control and Prevention and the EPA issued a joint statement regarding the resurgence of bed bugs. 5 years ago, it would be unusual to have a bed bug case in housing court. And the statement that they made noted that there's training and public education needed. That's the most important element as a problem-solving court, is training and education. Now, I do have an additional advantage of fines and jail time, which hopefully will be an incentive for people to take training and education to work on this problem. Now, there are a number of things going on across the country concerning bed bugs, and laws have passed, vary in scope. For example, some require a question regarding infestation be included on real estate disclosures. And if you're familiar with the lead statement, the HUD statement that's required by federal, state, and local ordinance, they're also requiring in Hawaii that there's a disclosure if there has been a bed bug infestation. And others, states are taking a more comprehensive approach, laying out legal obligations and rights for landlords and tenants, such as in New York and Arizona. And there's pending legislation in Massachusetts, New Jersey, North Carolina, here in Ohio, Oregon, and Pennsylvania. Now, looking at the state trends, the New York City Administrative Code has bed bug specific provisions. Landlords are to maintain rental premises free from bed bug infestation. Landlords must provide a 1-year bed bug history to new tenants when they move in. And if you look at Arizona's statute, landlords must maintain residential units free of infestation of bed bugs, provide existing tenants with a copy of the bed bug statute, sounds a lot like the lead disclosure statute, provide new and existing tenants with educational materials, and where the landlord fails to timely treat the infestation, the tenant may do so. They may treat the infestation and deduct the greater of $500 or half the monthly rent. Now, the tenant would have to hire a licensed exterminator, submit the invoice to the landlord in order to get that reduction. And under Arizona law, the tenant must maintain the unit free of bed bugs. They may not move in infested materials into the unit. They must notify the landlord of the presence of bed bugs within 3 days of discovery and comply with the protocols such as pre-treatment activities and reporting of the presence of bed bugs after treatment. They also may agree to be responsible for treatment if they're renting a single-family dwelling. So what's happening in Ohio? Well, we're moving right ahead, and Senate Bill 39 decided to study the problem and make recommendations. House Bill 129 seeks to establish a bug awareness program within a bed bug awareness program within the Department of Health. And Senate Bill 360 is to require notice of infestation to certain healthcare or other providers. So 2 of these are in committee and 1 has not been assigned to a committee. So we are seeing in the Cleveland Municipal Court Housing Division an influx of complaints about bed bugs and cases about bed bugs. And in fact, you've heard the statistics from the Cleveland Department of Health, and the complaints of bed bugs in the City of Cleveland Department of Health have doubled over the last 2 years. And criminal code violations seen in the housing court have increased. And in fact, within the last 2 years, we're starting to see bed bug cases and increasing at a great pace. Now, many people say, well, I'm a property owner, I can be held criminally liable for infestation of bed bugs, and the answer under our code is yes. There's also complaints of bed bugs on our civil inspection docket, and this is where the city is ordered to go out when there's been a complaint through landlord-tenant action. That has increased and has doubled from 2011 to 2010. And our court has established a task force internal to the court concerning bed bugs from every department, because not only are we seeing an increase in complaints of bed bugs, bed bug cases, we also are seeing introduction of bed bugs into the offices in the Justice Center, just like any other office building. And so it is our role to be proactive. We are also working with the General Division, Judge Adrian, and the Clerk's Office, Earl Turner, to try to develop a task force so an introduction of bed bugs does not become an infestation, because it could get out of hand with the volume and number of people that visit the Justice Center every single day. And it's interesting to note of the inspections on complaints with the bed bugs, only half of the complaints reveal that there actually are bed bugs. So there appears to be a gap in the public's perception and understanding of what the problem is. Now, what is the duty in the city of Cleveland concerning bed bugs? Well, and it's similar throughout the state. All dwelling structures in the premises shall be maintained free from sources of breeding, harborage, and infestation by insects, vermin, or rodents. Our ordinance does not specifically name bed bugs, but the codified ordinances listed as an infestation of pets. And many municipalities have similar ordinances. Now, what are the landlord's responsibilities? Well, landlords are required to comply with the requirements of all applicable building, housing, health, and safety codes that materially affect health and safety. They are required to make all repairs and do whatever is reasonably necessary to put and keep the premises in a fit and habitable condition. And you'll hear this, fit and habitable, as being a requirement that flows throughout the law of landlord-tenant. And they must keep all common areas and premises safe and sanitary. So what are the tenants' responsibilities? Well, they have to keep part of the premises that they occupy safe and sanitary, dispose of rubbish, garbage, and other waste in a clean, safe, and sanitary manner, and comply with requirements imposed on tenants by all state and local health codes, housing codes, and safety codes. And so this is the requirement for tenants under our Ohio Landlord Tenant Code. Now, there is an implied warranty of habitability. The lease agreement between the landlord and tenant is a contractual relationship with an implied warranty of habitability. Implied warranty is in addition to the statutory duties. Attempt to waive the implied warranty of habitability in a residential lease, such as putting in this apartment is rented as is or house as is unconscionable according to Ohio law. There are similar requirements in other states, and the properties become that they are habitable and it cannot be waived away by contract. Now, there is the Anderson case, which I noted here, which involved conditions requiring repair at the premises. It wasn't about bed bugs, but repair at the premises, and it illustrates lease provisions in an attempt to shift or contract away the warranty of habitability. And so, if you want more details on that, write down the site or see me afterwards. Now, it was 80 years ago, in 1930, that there was a case of first impression on bed bugs. And a landlord had sued for unpaid rent. The tenant counterclaimed, asserting that when he moved into the unit, he found it was infested with bed bugs. The matter was tried to a jury, which found the infestation was due to conditions in other units in the building. And the court found that the tenant was therefore constructively evicted. And this case was from 1930, and it was really a long time ago, and we're just starting to see cases from 2008. There aren't many cases on the issue of bed bugs in Ohio. However, the constructive eviction, that tenant couldn't live in the apartment with bed bugs. So then from 1930, we move forward to 2011, and there is a case from Lucas County, Kenwood Gardens Association versus Shorter. The tenants admitted that they brought the bed bug infestation to the premises. Upon notice of the infestation, the landlord promptly hired a professional exterminator. The tenants failed to properly prepare the unit for treatment. And then, in the case in Toledo, the tenants admitted that they brought the infestation, and because of their lack of cooperation, the treatment was ineffective. The landlord notified the tenants that without their cooperation, the condition could not be corrected. So the court in that case decided the tenants breached the lease by failing to pay rent during the infestation. The landlord did not breach the implied warranty of habitability, where tenants failed to cooperate with the extermination efforts. Therefore, there was judgment for the landlord on the claim for money damages in the Kenwood Garden case. And this case suggests that the courts will consider the level of cooperation and treatment regimes and the impact of the tenant conduct on that treatment. In fact, last year at the Cleveland Housing Court, we had an eviction claim based upon the tenant's failure to cooperate with treatment. The matter was a CMHA public housing case, and the premises involved was a multi-suite building. The housing authority had inspected and given the tenant several opportunities to prepare his unit for treatment. The tenant failed to properly prepare the unit, and after several attempts, the housing authority brought the eviction, asserting the tenant's failure to prepare was a breach of the lease and the tenant's statutory obligations. The court granted the eviction, noting the failure to comply with preparation for treatment. There's another case that we view as important, the Spring Hill Townhomes versus Pounds, where the tenants had occupied a unit for 2.5 years before the bed bug problem. The landlord exterminated and sought reimbursement from the parties, from the tenants. And the parties made a repayment agreement, agreed to pay the landlord back for the extermination services. But the tenants only made 2 payments. And so the landlord brought the eviction action and a money claim asserting back rent and the balance of the rent payment. The court decided in that case that the repayment agreement for extermination services between the landlord and the tenants was enforceable, absent evidence of economic duress caused by the landlord. However, the landlord, because the agreement did not mention the lease, the security deposit could not be applied against the balance owed under the extermination cost repayment agreement. So the landlord could not, in that case, deduct from the security deposit the cost of the pest control service. Yes. Yes. In that case, they made a side agreement. Well, here's what the cost of the services were, but they didn't mention it as being part of the landlord-tenant agreement, the lease for the premises, which they could amend, provided both of them agreed to it. So this decision sheds some light on how courts may view repayment agreements or agreements to shift or share the cost of extermination where the tenant is likely to have brought the infestation to the premises. However, causation remains open, and the housing court is unaware of any case law in Ohio or otherwise dealing with agreements to shift or share the cost when causation could not be determined. What caused the problem? And I'm going to talk a little bit about a case that we had where there was an issue of causation. Now, what is the cause? And that's something that we look at with the court. What is the type of dwelling? Is it single family or multifamily? What are the lease provisions? Have there been inspections? What is the history of infestation in the building or that unit? The history of the infestation at the tenant's previous location. And whether the parties are informed about the issues of bed bugs. Now, this year we've noted on our inspection docket from the court that the complaints about bed bugs have doubled. However, only about half of the complaints has it been confirmed. Some of the other factors that we look at, whether the infestation was timely reported, whether the infestation was professionally treated, the extent and location of the infestation, and then the opinion of a properly credentialed exterminator. Now, the exterminator, this certainly would be useful, but we're unaware of any exterminator who has been able to make the statement that this was caused by the tenant. They're able to tell us that there are bed bugs there, but they can't tell us if the bed bugs were brought in. So we did have a case in Cleveland in 2008, and that was really the first bed bug case that we saw at the Cleveland Housing Court. The tenant had suffered bed bug bites for 2 months after she moved into the unit. She notified the landlord, who promptly exterminated, but the tenant never returned to the unit and disposed of her personal property, including a newly purchased bed. And as part of the contested claim for money damages that the landlord sought against the tenant sought compensation for the loss of property. Look, I had to throw out my bed, I had to throw out my furniture, and this was a case that it's helpful to understand what the causation was. So the evidence that was provided in this court case, the infestation was confined to the tenant's bedroom. There was no infestation in the wall or baseboards of the bedroom. The majority of the bed bugs and casts were on the tenant's bookcase that were adjacent to the bed. And the landlord's exterminator was unable to state with reasonable certainty how that introduction of bed bugs occurred in that apartment. The tenant was uninformed about bed bugs and did not seek information on how to manage the situation, just went to the extreme of throwing everything out. And so the court therefore concluded the tenant failed to establish that the landlord or a previous tenant or an adjacent unit was responsible for introducing bed bugs. And the landlord therefore was not liable to the tenant for the possessions she threw away due to the infestation. So think back to that 1930 case, constructive eviction, if the place is so infested that you can't live there. And then think about this case, there has to be some proof. So the expert was unable to give an opinion as to the causation. So what may have been important is that the tenant acted, disposing of her bed and other possessions without gathering accurate information. She just threw them all out. And she had not gathered any information on adjacent units in the building or the history of infestation. So what an expert may or may not be required based upon the circumstances could be produced as evidence in the case, and there has to be basic knowledge about bed bugs and infestations and the history of the unit. So what does all of this mean? Well, it means that there has to be education and awareness. Landlords, tenants, property owners, building owners, health providers. There need to be inspections prior to renting or moving in, somewhat similar to inspections for lead or other hazards. There should be addendums to clarify what the rights are in case things go wrong, and what the obligations of each of the parties are. There should be a program for integrated pest management at the property, and there need to be periodic inspections of the apartment and at the move-out. And then payment agreements, who pays for this? So all the stakeholders must work together. Now, there are a number of resources, and here is, look what I got on the street for free. What if it has bed bugs? Free bed bugs. And we had a case about 6 weeks ago. The tenant, who was a refugee, would go out and recycle mattresses, bring them home, and strip them down to their springs and take them up to the scrapyard. Well, the property was infested with bed bugs, and they were just brought in. And you may drive around the city and see what is left of a mattress carcass on the tree lawn where these mattresses have been stripped out. But there has to be an education, and therefore the court a few weeks ago, in conjunction with the county and city health department bed bug task force, gave a seminar for landlords on what to look for. And this particular landlord, who was fined $2,000, and once he abated the nuisance of bed bugs, the fine was suspended by 90%. He's on a year of community control sanction because the probation officer from the court will go out and check. And what he has allowed is the tenants to clutter up the apartment, to bring the mattresses home, so he's failing to make sure that he is keeping the property in a situation that will not cause return of the bed bug and a greater bed bug infestation. So we hope he will understand that he has to enforce the rules about clutter, cleanliness, and used furniture on his property. Here are a couple of helpful websites in addition to what you see from CuyahogaBedBug.com and the other websites concerning the law, landlords, bedbug guides, lease addendums. And the point, I think, is, for all of us, is that do you want to spend $10,000 to target your property to try to eliminate the insect infestation, or do you want to spend a little money, even though it has a bed bug on it, you want to spend a little money to try to prevent an introduction of bed bugs from becoming an infestation. This is what we work on at the housing court every single day. We run a housing clinic. There are housing court specialists that are here, 2 magistrates, and so if you don't have time to ask questions directly, we'd be happy to answer them right after the seminar. And I want to thank the task force for putting this together. Extremely important for the work that we do. Are there any questions?